My neighbor filed 22 complaints against me. 22 code violations, encroachment notices, a harassment report. Every single one of them against me. Then one Tuesday morning, a certified letter arrived from the county. Not a courtesy notice. Not a form letter. A document with legal language in it. Words like encroachment upon the adjacent parcel and 30-day cure period and potential injunctive relief. The kind of language that means someone, somewhere, has decided this is no longer informal. She was standing at her fence when the mail truck pulled away. She called out loud enough for the whole street to hear, "I've been patient long enough. That land is mine and everyone knows it." I looked at her. I said, "Then you won't mind if I get the measurements confirmed in writing?" She laughed. She shouldn't have, because what that survey found didn't just answer her 22 complaints. It answered a question she never expected anyone to ask, about her fence, her deck, and exactly whose land she'd been standing on for the past 3 years. If you've ever had a neighbor treat your property like it was already theirs, drop your state in the comments. You need to see how this one ended. I want to be straightforward with you about who I am before I tell you what happened. I'm not a lawyer. I'm not someone who grew up knowing how property law works or what a boundary affidavit is or why a certified survey carries more weight than a county complaint form. I'm a guy who spent 30 years in facilities management, which is a formal way of saying I maintained buildings, fixed what broke, and kept records of everything because that's what the job required. I retired early, not because I had money, but because I'd saved carefully and I was tired. I bought this house 11 years ago, paid for it the slow way. Took me 6 years to find the right lot, corner placement, east-facing yard, enough room on the side for a proper driveway without crowding the neighbour's line. I knew what I wanted because I'd spent 3 decades managing other people's properties, and I knew exactly what made a parcel useful and what made it a headache. I moved in with my tools, my truck, and a plan to do nothing dramatic. Maintain the lot. Keep the fence clean. Mind my side of every line. And I did that. For 7 years I did exactly that. There is one thing I should have done that I didn't. When I bought the house, the seller provided a survey from the previous sale, about 14 years old at that point. I looked it over. The measurements seemed consistent with what I could see on the ground. I told myself it was fine. I never ordered a fresh survey. That was my mistake. Not a catastrophic one. Not even unusual. Most residential buyers don't commission new surveys unless the lender requires it. But it left me without an anchor, and when the complaints started coming, I had documentation for everything except the one thing that mattered most, the ground itself. She moved in 4 years ago. I remember the week clearly because she introduced herself twice, once at the door, once across the fence line, and both times she mentioned the property. Not the house, the property. The lot dimensions, the setbacks, the way the east side of my driveway sat close to what she called the shared corridor. I didn't think much of it at the time. Some people are particular about space. I understood that. The first physical thing I noticed was the storage bin. It appeared about 6 weeks after she moved in. A large plastic utility bin, the kind you'd use for garden tools, placed directly on the fence line between our properties. Not on her side. On the line, technically touching both parcels. I moved it back 6 inches without saying anything. A week later it was back in the same spot. Then her garden edge moved. She was doing legitimate landscaping, nothing you could object to, but the border of her east garden crept incrementally toward my driveway over 2 seasons. 6 inches one summer. Another 4 the following spring. I noticed it the way you notice a clock running slightly slow, not in any single moment, but one day you look up and realize 40 minutes are gone. She was pleasant in every direct conversation. That is worth saying clearly because it matters to how this worked. She never threatened me, never raised her voice in those early years. She would wave from the yard, make small talk over the fence, ask about my truck. The complaints, when they started, always came through official channels. Never face to face. That's the part I underestimated for too long. She understood something I didn't, not yet. That in a system like an HOA, the person who files first writes the first draft of the story. Every complaint she logged created a record. Every record made her look like the concerned party seeking resolution. By the time I understood what I was looking at, she had built 14 months of official paperwork that described me as the problem. She never needed to be loud. The forms were loud enough. I want to explain how the HOA complaint system works in this county, because if you don't understand the mechanics, the next part of this story won't make sense. When a complaint is filed, it gets logged. That's automatic. No review, no verification, no threshold of plausibility required. The complaint exists the moment it's submitted. From there, the HOA Management Office generates a notice to the named party, which was always me, and opens what they call an investigation, which in practice meant a staff member drove past the property, took a photograph from the street, and noted whether anything looked obviously wrong. Nothing ever looked obviously wrong, because nothing was wrong. But here is what I did not know for the first 14 months. Each complaint was being treated as an independent incident. There was no mechanism in the system that connected complaint 3 to complaint 11 to complaint 19. No flag that triggered when the same neighbour filed against the same property for the 18th time. No review process that asked whether a pattern existed. I had responded to 19 of the 22 complaints in writing. Detailed responses, photographs with timestamps, measurements I'd taken myself, dates, descriptions. I submitted every one of them through the HOA portal. They were all received and filed separately. Each response sat in its own folder, attached to its own complaint, reviewed in isolation. Not one person in that office had ever looked at all 19 responses side by side. Not one person had noticed that the same property, the same boundary, and the same neighbour appeared in every single one. The County Code Office operated on a parallel track that made this worse. When a complaint included the word structure, as several of hers did, it triggered a different pathway entirely. Code enforcement had its own logging system, its own inspection process, and its own notice generation procedure. The two systems did not communicate with each other. A code officer could issue a formal notice based entirely on a complaint's language without confirming which parcel the structure actually sat on. That is exactly what happened with complaint 22. The officer read the words permanent concrete pad and adjacent parcel and generated a certified notice. He did not verify the parcel number. He did not cross-reference the assessor's map. He sent a document with legal language in it to my address based on an unverified complaint because the system allowed him to. No malice required. The process did it on its own. The letter arrived on a Tuesday. I know it was Tuesday because I'd been out since 6 in the morning helping a former colleague move equipment out of a storage unit, and I got home just after noon with my back sore and my hands dirty. The mail truck was pulling away from the curb as I turned into the driveway. I didn't think anything of it. There was one envelope in the box that was different from the rest. Heavier stock. A green certified mail receipt attached to the front. My name and address printed through a label, not handwritten. Return address, County Code Enforcement Division. I stood in the driveway and opened it. The language was not casual. Encroachment upon the adjacent parcel. Permanent structure placed without verified survey. Cure period of 30 days from date of receipt. Failure to comply may result in injunctive relief sought by the county. I read it once straight through, then went back to the top and read it again more slowly. The way you reread something when your brain refuses to accept what your eyes are reporting. The concrete pad they were referencing was the corner of my driveway. I poured it 9 years ago. I pulled the permit for it myself. It had never been closer to her property line than my original lot measurements showed, the same measurements that came with the house at purchase. But none of that was in the letter. The letter did not ask questions. It stated conclusions. And it gave me 30 days to answer for something I had not done on land that was mine, using language that carried the weight of government authority behind it. That was the moment informal stopped being an option. My first instinct was to go directly to the source. Not to her. To the county? I wanted to sit across from a human being, put my documents on a table, and have someone explain to me how a certified notice with legal language gets generated without anyone verifying which parcel a structure sits on. That seemed like a reasonable question. I assumed it would have a reasonable answer. I went to the county assessor's office the following morning. I brought everything I had, the original purchase documents, the seller's survey from 11 years ago, printed copies of all 22 complaint responses I'd submitted through the HOA portal, and the certified letter itself. I waited 40 minutes. When I got to the window, the clerk looked through what I'd brought, listened carefully, and then told me something that stopped me cold. The certified letter was issued by Code Enforcement. The assessor's office and Code Enforcement were separate departments. They did not share a database. She could see my parcel record, confirm my ownership, and note the boundary as recorded, but she had no authority over a code enforcement action and no mechanism to flag their files from her terminal. She was apologetic. She was also correct. There was nothing she could do. I drove from the assessor's office to the HOA management office and requested a formal hearing. The manager, to his credit, scheduled one without argument, 3 weeks out, which was the earliest available slot. But he was also clear about something. The HOA hearing could address HOA-specific violations only. It had no jurisdiction over a county code action. The two processes would run independently on separate timelines with separate outcomes. Winning one did not affect the other. I was now fighting on two fronts that could not see each other. I drove home and sat in the driveway for a few minutes before going inside. Not out of despair, I want to be precise about that, but because I was recalibrating. I had spent 26 months responding to complaints individually, treating each one as its own problem to be corrected and closed. I had been thorough. I had been documented. I had been, by any reasonable measure, correct in every response. And I was still sitting in my driveway with a certified letter telling me to vacate a structure on my own property within 30 days. The approach wasn't working. Not because I was wrong, but because I was playing defense inside a system that had no mechanism for recognizing a pattern. Every response I filed disappeared into its own folder and was never seen alongside the others. The system wasn't designed to find the truth. It was designed to process individual complaints. That same week, before I'd even begun preparing for the HOA hearing, she filed complaint 23. This one alleged that a retaining wall on the east boundary was structurally unsafe and encroaching on her property. A wall that had been in place for 6 years. A wall I had maintained annually and that had never shifted position by a measurable amount. Complaint 23. Independent of everything prior. Fresh folder. Fresh investigation. I made a decision that evening that I should have made much earlier. That evening I cleared the kitchen table. Not to organize what I had. I'd been organizing for 2 years. I cleared it because I needed to look at everything at once in one place without the folder system I'd built that had been, without my realizing it, part of the problem. I had been filing my responses the same way the HOA filed her complaints, individually, neatly, each one in its own sleeve. I had built a very organized record of losing the same argument 22 times. I called a licensed land surveyor at 8:15 that night, not to prepare for the HOA hearing. The hearing wasn't the point anymore. The only document that was going to matter in any room, in any process, in front of any administrator or board member or code officer was a certified boundary survey. Current. Signed. Legally recorded. Something that didn't ask anyone to take my word for anything. I booked the survey for the following Thursday. Then I called my neighbour 2 houses down. I'll call him Alley number 1. He'd watched this situation develop from the beginning. He'd seen the storage bin move. He'd noticed the garden edge creep. He'd been present for 2 of the conversations at the fence line that I had logged in my own notes. I asked him if he would put what he'd observed into a written statement. He said he'd been waiting for me to ask. I told him I was done responding to the complaints. I was going to establish what was true in a form the system couldn't reroute into a folder and forget. The surveyor arrived at 7:30 on a Thursday morning. He was a licensed professional with 23 years of residential boundary work, and he brought 2 assistants and equipment I didn't fully recognize but understood the purpose of: GPS receivers, a total station instrument on a tripod, marking pins, a measuring wheel for cross-verification. He asked me to stay out of the measurement path but said I was welcome to observe from a distance. I followed at about 10 feet the entire time and took my own photographs of every stake placed, every pin driven, every reading recorded. I wrote the GPS coordinates in a notebook alongside what I could hear him dictating to his assistant. I wanted my own record, not because I didn't trust him, I did, but because I had learned, over the previous 2 years, that the only records that protected me were the ones I made myself. They started on the west boundary and worked east. The first 90 minutes were unremarkable. The measurements tracked closely with the seller's original survey, with minor drift well within normal tolerance for an 11-year-old document. I felt the particular tension of someone waiting for a result they believe is coming, but can't yet confirm. Then they reached the east boundary. The surveyor set his instrument, took 3 readings, and made a note without saying anything. Then he walked the line slowly from the rear of the lot to the front, stopping twice to place marking pins. When he reached the front corner, he turned to his assistant and said a number. His assistant repeated it and wrote it down. I asked him what it meant. He said the recorded boundary line ran approximately 4 feet east of where the current fence sat. Not 4 inches. 4 feet. The fence, her fence, the one she had installed roughly 2.5 years ago, was sitting inside my property. I stood there for a moment and did the arithmetic on what that meant. The 14-foot strip she had been claiming I was encroaching on was not contested land sitting between two uncertain lines. It was my lot. All of it. The fence she had built to define her territory was built on the wrong side of the boundary, on my side. But that wasn't the part that changed everything. As the surveyor completed the rear boundary measurements, he stopped at a section of her rear fence line and called me over. He pointed to a post and then walked a straight line from it to a pin he'd just placed. He explained in plain professional language that a section of her rear garden fence had drifted, or been installed, approximately 3.2 feet inside my recorded boundary. It had been there long enough that the soil around the base of the posts had settled and compacted. This was not a recent installation. I had walked past that fence line for 2 years and never questioned it. It had looked permanent. It had looked like hers. It was on my land. I took the surveyor's report to a property attorney 4 days after it was delivered. I want to be honest about why I waited 4 days. Not because I was uncertain about what to do next. I knew I needed a lawyer. But I wanted to read the report completely, multiple times, before I sat across from someone who charged by the hour. I wanted to understand what I was holding before I asked someone else to explain it to me. That's a habit from 30 years of facilities work. You don't call the contractor until you've diagnosed the problem yourself as far as you can go. The attorney was a woman who specialized in residential property disputes. Her office was small and orderly. A wood desk, a document printer on a credenza behind her, a single bookshelf with practice guides and state code volumes arranged by subject. She read the survey report without speaking for about 6 minutes. Then she set it down and told me I had more leverage than I likely realized, and that I had arrived at exactly the right moment, not too early and not too late. She explained 3 things. The first was a procedural tool called a boundary line dispute affidavit. This is a document filed directly with the county recorder's office that formally establishes the recorded boundary as controlling over any competing informal claim. When you attach a certified survey to it and file it as a matter of public record, it doesn't just win an argument, it changes the legal landscape permanently. Any future proceeding, any future complaint, any future claim involving that boundary has to contend with a recorded affidavit that pre-exists it. It becomes the ground truth on file. She said most homeowners in boundary disputes never file one because they don't know it exists, and most disputes get resolved or drag on unresolved through complaint and counter-complaint without either party ever anchoring the boundary in the public record. The second concept she explained was the adverse possession clock. In this state, a neighbour can claim legal ownership of land they've occupied continuously, openly, and without permission for 10 uninterrupted years. That clock runs silently. Most homeowners don't know it's running until it's too late. The fence encroachment on my east boundary had been in place for an estimated 2 to 3 years, well short of the 10-year threshold, but the clock was running. The way to stop it permanently was to file a boundary encroachment notice with the county, which creates an official record of the encroachment, establishes the date it was identified, and legally interrupts the adverse possession timeline. Once that notice is on file, the clock resets. It cannot run again from that point unless the encroachment is removed and a new one begins, which would start a fresh 10-year period. She paused after explaining that one and said, if I had waited another 7 years to get the survey done, the legal situation would have been considerably more complicated. The third thing she explained was the county's certified letter. She reviewed it against the Code Enforcement Procedure Manual she kept on file and identified the specific procedural failure. The code officer had issued a formal notice citing encroachment onto an adjacent parcel without confirming which parcel the structure sat on. The officer had relied entirely on the complaint's language and had not cross-referenced the assessor's parcel map before issuance. That was a procedural error on the county's part, documented in their own procedure manual, and it was grounds for a formal challenge that could void the notice entirely. She told me to go home and let her draft the filings. For the first time in 26 months, I left a meeting about this situation without anything to rebut. The attorney sent the formal notice letter on a Wednesday, certified mail. Her name and address on the envelope, just as mine had been on the county's letter 2 weeks earlier. Inside was a single document, notification that a boundary line dispute affidavit was being prepared for filing with the county recorder's office, that a certified survey had confirmed the recorded boundary and that the survey findings identified encroachments on my property that would be addressed through formal legal and administrative channels. The filing number was referenced. The surveyor's license number was referenced. The attorney's bar number was on the letterhead. It was not a threat. It was a notification. Precise, documented, and impossible to misread. She received it on a Thursday afternoon. I know this because the certified mail tracking confirmed delivery at 2:14 p.m. I was not watching for it. I checked the tracking once, noted the delivery, and went back to what I was doing. At 6:47 that evening, she knocked on my front door. I want to describe this moment carefully because it would be easy to make it into something it wasn't. She was not screaming. She was not threatening. She was composed in the way that people are composed when they are working hard to appear composed, which is different from actually being calm. She told me the survey was wrong. She said she had her own records, she didn't specify what kind, that showed the boundary line differently. She said the attorney's letter was an overreaction and that we could still resolve this between ourselves if I was willing to be reasonable. I listened to all of it. I did not invite her inside. I did not argue with a single point she made. When she finished, I told her that all communication going forward would need to go through my attorney, and I closed the door. The entire exchange lasted less than 2 minutes. I went to my desk and wrote it down immediately. The time, the duration, the substance of what she said, her exact phrasing where I could recall it. I noted that she had not arrived with any documents. I noted that she had used the word reasonable twice. That entry became document 47 in the case file. She moved quickly. I'll give her that. Within 72 hours of receiving the attorney's letter, she had hired her own surveyor. I found out the way I found out most things in this situation, not because anyone told me directly, but because I was paying attention. I was in the backyard on a Saturday morning when I heard voices on the east side of the fence. I walked to the corner of the house and saw a man with survey equipment attempting to set up a tripod on the shared boundary line. He was trying to position one of his instrument legs on my side of the fence. I walked over and asked him who had retained him. He gave me her name. I asked him if he had permission to place equipment on my property. He paused, consulted something on his clipboard, and said he had been told the boundary was contested. I told him the boundary was not contested. It was recorded, and a certified survey with a filed affidavit number confirmed it. I asked him to move his equipment back to her side of the line. He did without argument. He was a professional doing a job. He hadn't been told the full picture. I called my attorney from the driveway and left a detailed message. The second move came 2 days later. She contacted 2 HOA board members directly, by phone, not in writing, and requested an emergency session to challenge the survey. She told them the surveyor I had hired was not neutral, that he had a prior relationship with my attorney, and that the findings were therefore compromised. Neither claim was true. More importantly, neither claim was made in writing, which meant neither claim entered the official record. My attorney noted that when people make serious allegations verbally and avoid putting them in writing, it usually means they understand the allegation won't survive documentation. The third move was complaint 24, filed the following Monday, alleging that I had tampered with boundary markers during the survey process. It was the most serious complaint she had filed. Tampering with survey markers is a criminal allegation in most states. It was also, like everything else, completely unsubstantiated. But it was in the system now, and the system would log it. My attorney filed a title search on both parcels the following week. This is standard procedure in boundary disputes. You pull the full ownership and recorded instrument history for both properties to confirm there are no competing claims, easements, or encumbrances that could complicate the affidavit filing. I hadn't requested it specifically. She ordered it as a matter of course. I'm glad she did. The results came back on a Friday afternoon. She called me directly, rather than sending them by email, which told me before she said a word that something in the report required a conversation. She walked me through the east boundary findings first, everything consistent with the survey, nothing unexpected. Then she moved to the rear boundary of the adjacent parcel, her parcel, and she read me a section of the title report that I asked her to repeat twice before I said anything. Antagonist's rear deck, a structure she had built approximately 3 years ago, which I had seen go up over the course of a single weekend and thought nothing of, extended 1.8 feet past her recorded rear property line. Not into my lot directly, into a municipal alley easement that ran along the rear of both properties. The easement was owned by the municipality and was recorded as a drainage and utility corridor. My lot was listed in the easement record as the adjacent affected parcel. I sat with that for a moment. She had filed 24 complaints against me for alleged encroachment. She had accused me of placing a concrete pad on her land, building an unsafe retaining wall, tampering with survey markers. She had generated 2 years of official paperwork positioning herself as the party seeking legitimate boundary clarification. And she had built an unpermitted structure that crossed a municipal easement and was listed as affecting my property. But the attorney wasn't finished. She explained that the deck's position had altered the natural drainage gradient along the rear of both lots. The easement corridor was designed to carry surface water away from adjacent properties. The deck's footings and base had partially blocked that corridor. The result was redirected water flow onto my east side. I thought about the low patch in my rear yard, the slow pooling after heavy rain that I'd noticed for the past 2 growing seasons, the soil in that corner that never fully dried out between wet periods. I had regraded it once and assumed the problem was compaction. It wasn't compaction. It was her deck. My attorney submitted a public records request the same week the title search came back. In most counties, HOA complaint filings that result in official notices become part of the administrative record and are accessible through a standard records request. It takes time, sometimes 2 weeks, sometimes 4, but the full filing history comes back with timestamps, submission metadata, and in some cases, the IP address or account login associated with each filing. My attorney requested everything. Every complaint, every timestamp, every piece of submission data the county system retained. The documents arrived on a Thursday in a manila envelope, thick enough that I noticed the weight before I opened it. I spread them across the kitchen table and started with the dates. The pattern was visible within 20 minutes. She had not filed complaints steadily or randomly. She had filed them in clusters, 3 or 4 within the same week, sometimes within the same 48-hour window. I cross-referenced those clusters against my own property records. The correlation was not subtle. Complaint cluster 1, 4 filings in 5 days, submitted the week after I had my driveway professionally seal-coated. Complaint cluster 2, 3 filings, submitted 9 days after I pulled a permit for a storage shed on the west side of the lot. Complaint cluster 3, filed the same week I had the east fence repaired by a contractor whose truck would have been visible from her property for 2 days. Every cluster followed a documented improvement to my property. The timing was too consistent to be coincidental. These were not reactions to genuine concerns about boundary violations. They were responses to evidence that I was actively maintaining and improving the lot, which, to someone building a long-term encroachment strategy, would register as a threat. But the last entry in the record stopped me completely. Complaint 21 had been filed on the same calendar date that my shed permit was issued by the county. Not the day after. Not the week after, the same day, before the permit would have appeared in any public-facing database, before a neighbour watching from a window could have seen any construction activity. She had known about the permit before it was public. I sat at that table for a long time after that. I want to stop here for a moment before I tell you what happened next. Not for drama, because I think if you've been following this closely, you deserve to have the full picture laid out in one place before we move into what I did with it. And because I needed to do exactly that myself, sit down, clear everything else away, and read the complete ledger before I took another step. 24 complaints filed against me over 26 months. Not one of them resulted in a confirmed violation. 2 county inspections. Both returned no findings. 1 courtesy notice issued in error by a code officer who did not verify the parcel number before generating a legal document. 1 certified letter demanding I vacate a structure on my own property within 30 days. 1 certified survey confirming the recorded boundary, identifying a fence encroachment of 3.2 feet inside my lot and placing the east boundary line 4 feet from where she had been claiming it sat. 1 title search revealing an unpermitted deck encroaching on a municipal easement, redirecting drainage onto my property for 2 growing seasons. 1 public records request revealing a complaint filing pattern timed precisely to my permit activity and property improvements. I sat with all of that at the kitchen table and I tried to name what I was feeling accurately. It wasn't anger. Anger had come and gone many times over 2 years and hadn't accomplished anything. It was a specific kind of tiredness, the kind that comes not from the fight itself but from being right for a very long time inside a system that kept asking you to prove it again. I was done proving it piecemeal. Everything was going in at once. My attorney and I met on a Tuesday morning and spent 2 hours going through every document in the case file. Not to review what we already knew, we both knew it. We went through it to make sure that what we were about to file was airtight on every front simultaneously. Because that was the decision we had made, not to file sequentially, not to start with the strongest claim and add others as responses came back, but to file everything at once on the same day through every applicable channel so that no single action could be isolated, contested, and delayed while the others waited. She had spent 2 years filing complaints one at a time into a system that processed them one at a time. I was going to do the opposite. The first filing was the boundary line dispute affidavit submitted to the county recorder's office with the certified survey attached as Exhibit A and the full title search as Exhibit B. The affidavit formally established the recorded boundary as controlling over any competing informal claim and created a permanent public record that would appear on any future title search for either parcel. From the moment that document was stamped and recorded, the boundary was not a matter of dispute. It was a matter of public record. The second filing was the boundary encroachment notice, submitted simultaneously to the county recorder's office. This document formally identified the fence encroachment, 3.2 feet inside my recorded boundary, present for an estimated 2 to 3 years, established the discovery date, and permanently interrupted the adverse possession clock. The clock that had been running silently for 2 to 3 years stopped that morning and could not resume from that point. The third action was a formal written challenge to the County Code Enforcement letter, submitted directly to the Code Enforcement Division's Administrative Review Office. The challenge cited the specific procedural error, issuance of a formal notice without parcel verification, cross-referenced the division's own procedure manual, and requested both a review of the notice and a written response confirming its status. My attorney attached a copy of the certified survey and the assessor's parcel map showing the concrete pad's location clearly within my recorded boundary. The challenge also requested that the 30-day cure period be placed on administrative hold pending the review outcome. The fourth action was a drainage interference complaint filed with the Municipal Public Works Department. This complaint identified antagonist's rear deck as an unpermitted structure encroaching on a recorded municipal easement, described the drainage redirection caused by the deck's footings and base, and documented the resulting water pooling on my lot with photographs taken over 2 growing seasons. Public Works had its own inspection and enforcement process, entirely separate from the HOA and code enforcement tracks, which meant this complaint would generate its own investigation and its own findings independent of everything else in motion. The fifth and final action was a formal written submission to the HOA, signed by both me and alley number 1, requesting that all 24 complaints filed against my property be reviewed as a pattern rather than as individual incidents. The HOA's own bylaws contained a provision, one the manager had never mentioned to me in any of our conversations, that required the board to conduct a pattern review if 3 or more complaints against the same property were formally disputed in writing simultaneously. We were disputing 24. The bylaw gave the board no discretion on whether to conduct the review. It was mandatory. Alley number 1's written statement was attached. 2 pages, single-spaced, dated and signed. He described what he had observed over 4 years: the storage bin placement, the garden edge movement, the fence installation, the deck construction, and 6 specific conversations he had witnessed between me and antagonist at the fence line. He wrote it in plain language without editorializing, and it read exactly the way a credible witness account should read. Everything was submitted before noon. By 3 o'clock that afternoon, my attorney had received confirmation of filing from the county recorder's office. By 4, the Code Enforcement Administrative Review Office had logged the challenge and placed the certified letter on hold pending review. The 30-day clock that had been running against me since that Tuesday morning 3 weeks ago stopped. I drove home in the late afternoon and parked in my driveway, the same driveway that had been the subject of complaint after complaint for 2 years, and sat in the truck for a few minutes before going inside. The concrete pad was exactly where it had always been, right where it belonged. The call came on a Thursday morning, 11 days after the filings. My attorney called me first before the written confirmation arrived because she said she wanted me to hear it from a person rather than read it off a piece of paper. The Code Enforcement Administrative Review Office had completed their internal review. They had confirmed the procedural error. The code officer had issued the certified notice without verifying the parcel number against the assessor's map. The notice was formally invalid. They were retracting it. A written retraction would arrive by certified mail within 5 business days. I thanked her, set the phone down on the kitchen counter, and stood there for a moment. The retraction letter arrived 4 days later. Same heavy envelope stock as the original. Same green certified mail receipt on the front. Same county return address. I opened it at the kitchen counter, standing in the same spot where I had opened the original letter 8 weeks earlier. It was 3 paragraphs. The first acknowledged the original notice. The second cited the procedural error in plain administrative language. The third formally rescinded the 30-day cure demand and closed the code enforcement case with a finding of no violation. I read it once, set it on the counter, opened the case file binder and placed it behind the original letter in chronological order, the way I had filed everything else. I did not feel triumph. I want to be honest about that because I think triumph would have been the wrong response and some part of me knew it. What I felt was something closer to a debt being partially repaid. The county had sent me a document that treated me as someone who had done something wrong. Now they had sent a document saying they were mistaken. That was correct. It was also 2 years too late. Winning on paper does not give back 26 months. For 3 weeks after the filings, things were quiet. Not resolved. I want to be precise about that distinction because I made the mistake of not being precise about it myself. The filings were complete. The certified letter had been retracted. The adverse possession clock had been stopped. The HOA pattern review had been formally triggered. On paper, the situation looked like it was winding down. It wasn't. I should have anticipated that someone who had spent 2 years building a complaint record would not simply stop because the record had been challenged. The strategy had been to exhaust me through process. When the process turned, the instinct was to generate more process, not to withdraw from it. The first move came from her privately hired surveyor. 22 days after my filings, he submitted a counter-survey report to the HOA claiming a 2-inch discrepancy in the east boundary measurement. Not 2 feet, 2 inches. An amount that fell well within standard survey tolerance and had no legal weight against a recorded affidavit. But it was a document. It existed, and its existence gave the HOA administrative grounds to request a secondary review before closing the pattern complaint process. My attorney reviewed the counter-survey and described it in a single sentence. It was designed to create delay, not to establish truth. We responded in writing, attached the relevant sections of the state surveying standards that defined acceptable measurement tolerance, and noted that a 2-inch discrepancy within tolerance did not constitute a boundary dispute under any applicable statute. The HOA acknowledged the response and continued the pattern review. The second move was larger, and it was a mistake. When the HOA formally requested documentation from both parties as part of the pattern review, she submitted a written response. 12 pages. I received a copy through the HOA process as the named party in the review. I sat down and read all 12 pages the evening they arrived. Most of it was a restatement of arguments she had made before. The boundary was unclear, the survey was compromised, my responses to the complaints had been inadequate. I had answers for all of it, and so did my attorney. But on page 9 there was something new. She alleged in a formal HOA proceeding that my original property purchase had been based on a fraudulent description in the listing, that the seller had misrepresented the boundary in the listing documentation, that I had either known about this misrepresentation or should have investigated it before purchase. There was no documentation attached, no exhibit, no reference to a specific listing record or recorded instrument. Just the allegation, stated plainly, in a document that was now part of a formal HOA proceeding and therefore part of the official record. My attorney called me the next morning. I could hear something in her voice that I had not heard before in our conversations. Not alarm, but a focused attention, the way someone sounds when they recognize an opening. She said she just made a very serious allegation in a formal proceeding without a single piece of evidence to support it. She said that's called defamation exposure. And she created it herself. The Municipal Public Works Department sent an inspector on a Wednesday morning, 6 weeks after I had filed the drainage interference complaint. I had not received any communication from them in the intervening weeks. No acknowledgement, no status update, no indication of whether the complaint had been logged or reviewed or set aside. That silence had been one of the harder parts of the post-filing period. When you have 5 actions in motion simultaneously and 4 of them are generating responses, the one that isn't becomes the one you watch. I had checked the Public Works complaint portal twice a week and seen no movement. The inspector arrived without advance notice, which I later learned was standard procedure for drainage and easement complaints. They prefer to observe conditions as they exist, rather than after a property owner has had time to prepare. He introduced himself at my front door, showed his credentials, explained the nature of the inspection, and asked if I would walk the rear boundary with him. We were back there for 40 minutes. He measured the deck extension with his own equipment, photographed the easement corridor from 3 angles, and took soil samples from the pooling area on my east side. He did not offer opinions while he worked. He asked me 2 direct questions: when I had first noticed the pooling and whether I had made any modifications to the rear grade. I told him the pooling had begun approximately 2 years ago and that I had regraded once, which had not resolved it. He noted both answers. He left without telling me what the findings would be. The notice of violation arrived at her address 19 days later. My attorney received a copy as the complainant of record. It was a formal municipal document, not an HOA notice, not a code enforcement courtesy letter, but a violation notice issued by the Public Works Department, citing encroachment on a recorded municipal easement and directing her to either remove the deck encroachment or obtain a retroactive permit within 60 days. It was the first time in the entire history of this situation that an official government action had been directed at her rather than at me. The HOA pattern review concluded the following week. The board had reviewed all 24 complaints, cross-referenced them against my submitted responses, the certified survey, the title search findings, and Ally No. 1's written statement. Their finding was formal and specific. 18 of the 24 complaints filed against my property had lacked documented basis at the time of filing. Not contested basis. Not ambiguous basis. No documented basis. The board voted to enter this finding into the official HOA record, which meant it was now a permanent document, one that any future buyer of either property could request and review. That same week, Ally No. 1 attended the monthly HOA meeting. He was not alone. 2 other homeowners from the street came with him. None of them stood up to attack her. None of them made it personal. They each took their 2 minutes during the open comment period and said a version of the same thing. The complaint filing process needed a verification requirement. Before a complaint about a property boundary could be logged, it should require a survey reference, a county record citation, or some form of documented basis. The board chair listened, asked 2 clarifying questions, and placed a bylaw amendment proposal on the agenda for the following month's vote. It was the first meeting about any of this that I did not attend. I had said everything I needed to say in writing through proper channels in 47 documented entries. I stayed home and let the process finish what the process had started. The retroactive permit application was denied within 30 days of the violation notice. I learned this through my attorney, who had maintained contact with the Public Works Department as the complainant of record. The denial was not complicated or ambiguous. The deck extension crossed a recorded municipal easement, and the municipality does not issue permits for permanent structures within easement corridors, regardless of when the structure was built or how long it had been in place. The easement existed to maintain drainage and utility access. A deck built across it was not a matter of insufficient paperwork. It was a structural conflict with a recorded public right. She had 60 days from the violation notice to either obtain the permit or remove the encroaching portion of the deck. The permit was denied at day 29. She now had 31 days remaining to remove the structure at her own expense. My attorney sent a formal demand letter the same week the permit denial was confirmed. The letter was measured and specific. It documented 2 years of drainage interference caused by the deck's alteration of the easement corridor. It attached the soil sample findings from the Public Works inspection, my own photographs of the pooling area taken over 2 growing seasons, and a written estimate from a landscaping contractor for regrading and drainage restoration on my east side. The total amount was not large in litigation terms, under $4,000, but the legal basis was solid and thoroughly documented, and there was no procedural counter available to her. The violation notice, the permit denial, and the Public Works inspection report had established the facts in an official record she could not challenge. Her real estate attorney responded within 2 weeks, not with a counter-argument, with a settlement proposal. The offer acknowledged the boundary, as recorded in the boundary line dispute affidavit. It committed to the removal of the encroaching fence and its relocation to the correct boundary line at her cost within 90 days. It included a cash payment for the drainage damage, and it contained one additional item that my attorney had not requested, but that her attorney had apparently advised her to include: a written withdrawal of the fraud allegation, full retraction, signed, notarized, stating explicitly that the allegation made in the HOA proceeding was without factual basis and was withdrawn in its entirety. My attorney called to walk me through the terms. When she finished, she asked if I had any questions. I told her I had one. I asked whether accepting the settlement meant the HOA pattern finding and the Public Works violation record would remain in place regardless. She said yes. Those were institutional records. The settlement between private parties had no effect on them. I told her to send the acceptance. The county closed the code enforcement case formally in writing 6 weeks after the settlement was signed. The closure letter used specific administrative language that my attorney had requested during the challenge process, not just a case closure but a documented finding. The letter stated that the original notice had been issued in error due to a failure to verify parcel identity prior to issuance, that no violation had been found on the subject property at any point during the investigation period, and that the notice was rescinded in its entirety. It was signed by the division supervisor, not a staff clerk. I had asked for that level of specificity deliberately. A case closure that simply said resolved would have left the original notice sitting in the file as an unanswered document. What I received instead was a formal acknowledgement of institutional error, the county stating in its own language, on its own letterhead, that it had made a procedural mistake that resulted in a legal demand being sent to someone who had done nothing wrong. I requested 2 certified copies. One went into the case file binder. One went into a separate folder I kept in a different location. The boundary line dispute affidavit was now a permanent fixture in the public record. My attorney pulled a sample title search on my parcel after the recording was confirmed and walked me through what any future buyer, lender, or attorney would see when they ran the chain of title. The boundary was there. The survey was attached. The encroachment notice was there. The adverse possession clock stopped and dated. Anyone who looked at that parcel from this point forward would see the ground truth first. The case file binder sat on the shelf in my home office. 47 logged entries. The original certified letter in the front. The county's retraction behind it, the settlement agreement near the back, the fraud allegation withdrawal behind that. I did not need to display any of it. I just needed to know it was there, in order, in a form the system could not reroute into a folder and forget. The HOA bylaw amendment passed 3 months after Ally No. 1 first raised it at the open comment period. The vote was not close. The board reviewed the proposed language, made 2 minor adjustments to the verification threshold, and passed it with a majority that included every member who had been present during the pattern review findings. The amendment was straightforward in its requirements. Any complaint alleging a property boundary violation had to include, at the time of filing, either a survey reference, a county parcel record citation, or a written description of the observable basis for the claim. Complaints submitted without one of these 3 elements would be returned to the filer without logging. They would not enter the system. They would not generate a notice. They would not begin a clock. It was a small procedural change. 1 paragraph in a document most homeowners in the community had never read. But I understood, in a way I don't think everyone at that meeting fully did, exactly what that paragraph meant. It meant that what had been done to me, the 2 years of unverified complaints, the cascading official records built on nothing, the certified letter generated by a system that never checked its own assumptions, could not be done the same way again. Not in this community. Not through this process. That matters. Not because my situation was unique, but because it wasn't. 2 homeowners approached me privately in the weeks after the vote. Not together. Separately on different occasions, in the kind of quiet conversation that happens at the edge of a parking lot or at the end of a driveway. Both of them told me they had experienced similar complaint patterns from the same general direction over the past 3 years. Neither of them had known about the other. Neither of them had known about me. They had each handled it alone, the way I had handled it alone for 14 months, responding to each complaint individually, filing their rebuttals into separate folders, wondering why the system kept treating them as the problem. I gave them both the name of my attorney. I told them what I had learned, which was this: the complaint is never really about the complaint. It is about the record the complaint creates, and the only answer to a false record is a true one, documented, filed, and permanent. Her house went on the market 8 months after the settlement closed. I noticed the listing sign from my driveway one morning and looked at it for a moment before going inside. I did not know where she was going. I did not need to. The fence line had been corrected. The drainage had been restored. The boundary was in the public record where it belonged. I still live here. On my property? Every foot of it.